Welcome to PwC's IFRS Talks, your source for all things IFRS. I'm your host, Laura Kennedy, and in this episode, I'm joined by IFRS Talks regular and IFRS Interpretations Committee member, Karsten Ganssauge, to find out what happened at the committee's March meeting. Hi, Karsten. Welcome back to IFRS Talks.
Thank you, Laura. Glad to be back.
So last week, you were at the most recent IFRS Interpretations Committee meeting. It was the March meeting, and it was our first meeting in 2024. So I can see you had 3 items on your agenda. So 2 items were bringing stuff back to finalise agenda decisions. So there we had climate-related commitments, which is something you and I discussed in the December podcast, first of all. And then secondly, I can see you have another agenda decision, which was to do with IFRS 3. And then lastly, I can see the post-implementation review of IFRS 9 was on the table as well. So maybe starting in order with the climate-related commitments. Karsten, we had a long discussion on this when it first came to the committee. Can you provide our listeners with a recap of the issue?
Sure. But before I do that, let me maybe spend 2 minutes giving a bit of background, as this submission is a bit unusual in that it has gotten quite a bit of attention from a wider group of stakeholders. Now, as our listeners will be aware, climate-related commitments are really important topics for society at large and are getting quite a bit of attention from stakeholders that go beyond those that usually follow this podcast. So the accounting for these commitments is just one out of many aspects related to climate-related commitments. However, even so, this clearly is quite a hot topic, and many stakeholders have strong views on what the right accounting for climate-related commitments is, or what it should be, with some considering whether potential changes to IFRS accounting standards might be warranted. So I think it's fair to say that not just accountants, but also other stakeholders are highly interested in these topics. So I expect that we might have quite a few folks with a background other than accounting listening into our podcast today. So given that background, I think it's important to remind folks of the role of the IFRS Interpretations Committee, which is to interpret what IFRS accounting standards currently require, and in some cases to provide input to the ISB, which might include recommending to the board possible amendments to the current requirements in IFRS accounting standards. Now, with that in mind, let me come back to your question and remind our listeners about the specific question that had been submitted and discussed by the committee back in November of last year. So, in the submitted fact pattern, an entity publicly states to reduce its greenhouse gas emissions by a certain percentage within a certain time, and thereafter to offset its remaining emissions by buying and then retiring carbon credits. So essentially, the fact pattern included 2 types of commitments. First, an emissions reduction commitment, which is to reduce the entity's greenhouse gas emissions by a specified amount by a specified future date. And second, an offset commitment, that is, to offset the entity's residual greenhouse gas emissions after that future date by purchasing and retiring carbon credits. Now, the questions raised to the committees on this were essentially how the provision standards IS 37 applies to such climate-related commitments. More specifically, the committee considered whether an entity's net zero transition commitment gives rise to a constructive obligation of the entity, and if so, whether the entity recognizes a provision for that obligation.
Thanks, Karsten. So this went out for the usual public consultation with a tentative agenda decision. Can you share with us what feedback did you receive as a committee and how did you proceed with that?
Sure. Now the committee observed back in November that whether a constructive obligation will be created by an entity's statement of its commitment to reduce and offset greenhouse gas emissions depends on the specific facts of the statement and the circumstances surrounding it. Now, even though not part of the tentative agenda decision, or TAD, I think it's interesting to note that the November staff paper included some considerations that might be helpful in making that assessment, including the language being used in the statement and the specificity and status of plans supporting the statement. The committee also observed that the past event creating a present obligation will be the future greenhouse gas emissions the entity has committed to offset, not the public statement. Therefore, even if the statement does create a constructive obligation, the entity would not recognize the provision when it makes the statement. So it's only when the entity actually emits the greenhouse gases it has committed to offset that it will incur a present obligation, which is to retire the carbon credits required to offset its emissions. So only at that point, that is, when the related greenhouse gas emissions are made, would the entity recognize a provision for its commitment to retire carbon credits. That is assuming, of course, that the other criteria for recognizing a provision would be met, including that a reliable estimate can be made of the amount of the obligation, which I think would generally be the case in practice. Now, the committee received more than 40 comment letters on the tentative agenda decision, or TAD, significantly more than we usually get, with most commentators agreeing with the committee's conclusion and its tentative decisions. Now, considering the feedback from comment letters, the committee reaffirmed and finalized its decision that IAS 37 provides a sufficient basis to answer the question raised. So, to summarize, the key points are that whether a constructive obligation exists depends on the specific facts and circumstances. However, even when there is a constructive obligation, the past event triggering a present obligation will be the emission of the greenhouse gases the entity has committed to offset, not a public statement about future emissions reductions. Also, I think it's interesting to note that in order to recognize the provision and assuming a reliable estimate of the amount of the obligation can be made, there needs to be a probable outflow of economic resources. That is not simply an exchange of economic resources, but rather an outflow of economic resources. So the committee also discussed quite a few clarifying wording changes based on the feedback received, but these did not result in any fundamental changes in direction as compared to the TAD. Now, even though climate-related commitments might not be recognized as provisions in the financial statements at the time when the commitment is made, I think it's important to see the broader picture here. For example, I think it's quite important to highlight that there are other reporting requirements that might already capture these commitments and which might provide useful information to stakeholders. So, for example, these commitments might need to be recognized in other ways at an earlier date. For example, it could affect the useful lives of the assets, and it might also have an impact on impairment calculations. Also, I think it's important to note that the ISB has an active project on IAS 37 on its agenda and is currently working on amendments to IAS 37, which is expected to include an example on climate-related commitments. In addition, climate-related targets and commitments will be a key component of the IFRS sustainability disclosure standards, which is also intended to provide relevant information to stakeholders beyond what is captured in historical financial statements. So I think it's quite important to keep this broader picture in mind when looking at the outcome of this submission. Finally, it's probably worth mentioning that during the comment period, the committee also received a second submission on similar fact patterns from the original submitter.
Thanks, Karsten. Really helpful there to see how the IAS 37 requirements fit into that wider puzzle when it comes to climate-related commitments. Maybe then just to follow up on that second submission that came through, what extra information was in there that wasn't in the original submission?
So the submitter explained what they regard as limitations of the fact pattern described in the TAD. The submitters described two other fact patterns similar to that in the TAD, but with additional information about various actions the entity has taken to affirm its intention to transform to net zero. The submitters suggest that in these fact patterns, the entity has created a constructive obligation and should therefore by default recognize a provision. Further, if the entity concludes not to recognize a provision in those fact patterns, it should provide disclosures of contingent liabilities.
And so you already mentioned that at the recent meeting, the committee reaffirmed the views on the original submission from its November meeting. What did the committee conclude regarding this second submission?
Well, whilst public statements by an entity and other actions that affirm its intentions might be relevant factors when assessing whether an entity has a constructive obligation, neither of those are the past events that give rise to a present obligation. IAS 37 requires not just an obligation, but there are other criteria for recognizing a provision, which include that there must be a present obligation resulting from a past event. Therefore, even in case that these actions create a constructive obligation, that would not be sufficient to meet the criteria in IAS 37 for recognizing a provision. In order to recognize a provision, the entity must also have taken the actions to which the commitment applies. Therefore, a provision is only recognized when that event, that is the emission of greenhouse gases the entity has committed to offset, occurs. Now, the staff analysis suggested, and the committee agreed, that the additional fact patterns on climate-related commitment raised in the second submission do not raise technical issues beyond those that are already addressed in the TAD, and do not affect the conclusions set out in the TAD. The committee therefore concluded that from a technical perspective, the second submission does not raise new technical accounting issues, and also does not warrant re-exposure of the TAD that was published in December 2023 following the November IFRIC meeting. However, my sense is that the second submission was actually quite useful, as it helped to think through to what extent the principles laid out on the first submission could be applied also to other real-life climate-related commitments. So based on that, there was quite a bit of discussion on specific aspects of the TAD, including several aspects of the wording, and subject to these drafting changes, as mentioned, the committee voted to finalize the agenda decision. As always, subject to non-objection from the board. I think it may be interesting to note that the vote was unanimous. That is, all committee members agreed with the technical analysis and conclusions based on the current requirements in IFRS accounting standards.
So, next up on the agenda then, you also had a follow-up item. So last time you discussed this was back in the September committee meeting last year. And it's an IFRS 3 question, and it's related to payments that are contingent on continued employment. So, Karsten, can you share a bit with us about this issue?
Yeah, sure. So the committee received a request about how an entity accounts for payments to the sellers of a business it has acquired, if those payments are contingent on the seller's continued employment during a post-acquisition handover period. So in the submitted fact pattern, an entity acquires a business and as part of the agreement requires the sellers to continue as employees of the acquired business in a handover period to ensure appropriate transfer of knowledge to the new management team. Now, assume that the sellers are compensated at a level comparable to other management executives, and that the entity agrees to make additional payments to the sellers contingent upon both the performance of the acquired business and the continued employment of the sellers for a limited period after the acquisition to complete the handover of the business. Now, the sellers are entitled to receive the additional payments if their employment is terminated due to specified circumstances, such as, for example, death or disability, which is often referred to as God leaver clauses. However, the sellers forfeit the additional payment if their employment is terminated in any other circumstances. So, for example, if the sellers decide to leave the entity before the end of the handover period. So, buyers are often keen to have a proper handover of the acquired business, and it can sometimes be tricky to distinguish between what the selling shareholders receive as compensation for the business from what they would receive for post-acquisition services.
Thanks, Karsten. So that sounds like quite a common situation that can occur. What feedback did the committee get on that, and how did it conclude?
Now, for background, a similar fact pattern to the one submitted had already been discussed by the committee back in 2013.
Yeah.
Now, when the committee discussed this submission at the September 2023 meeting, it observed that the evidence gathered did not indicate significant diversity in accounting for such fact patterns. That is, entity applied the accounting described in the agenda decision issued back in 2013 and treats such payments as compensation for post-combination services rather than additional consideration for the acquisition. The committee therefore concluded that the matter described in the submission does not have widespread effects and tentatively decided not to add a standard-setting project to the work plan. I think there were no real surprises from the comment letters on this one. So we received 11 comment letters on this, and most respondents agreed with the committee's decision not to add a project to the work plan for the reasons set out in the TED. However, some respondents disagreed because in their view, the ISB should reconsider the related requirements in paragraph B55 of IFRS 3, and a few respondents also raised concerns about the accounting outcome of that approach in some circumstances. So I think committee members did acknowledge the concerns of some respondents about the outcomes of the 2013 agenda decision in some situations. However, the committee's role is not to assess the usefulness of information. That is the role of the ISB. Overall, since the issue was already considered in a previous agenda decision and there was no evidence of significant diversity, this was quite a short discussion and the committee decided to finalize the agenda decision as proposed by the staff.
So that brings us on then to the last item that you had on the agenda, and that was the post-implementation review of IFRS 9. Karsten, can you let us know what you were asked and how that discussion went?
Sure. So committee members were asked for their views on particular application matters in the financial instrument space related to impairments of financial instruments that have been identified by the staff, and in particular whether these matters are pervasive and are likely to have substantial consequences, and also what committee members consider to be the root cause for the identified matters. Now, we don't have time to go into the details of that discussion, but on a high level, there were 4 areas raised for discussion at the committee. First, intragroup financial instruments, such as intercompany loans. Second, loan commitments. Third, financial guarantee contracts. And fourth, purchase or originated credit-impaired financial assets. Now, personally, out of those 4 areas, I've heard most concerns around the costs involved with measuring expected credit losses, or ECL, on intragroup instruments, and also a few concerns relating to the accounting for financial guarantee contracts. However, whilst I think there are clearly a few application questions in the areas raised by the staff that could be considered, overall, my sense from the discussions at the committee was that there appears to be that there appear to be more important issues that should be considered as part of the IFRS 9 post-implementation review on impairment. Now, the committee was not asked to provide input on those other areas at this point because the board already has sufficient information about the pervasiveness and consequences of those other matters. But even though not discussed at the committee at the March meeting, let me maybe add a few observations and personal thoughts for our listeners on which areas I think will be key challenges in the IFRS 9 PIR. So my sense is that hot topics in the IFRS 9 PIR and the impairment area are likely to include in particular 2 things. First, the interaction between the IFRS 9 impairment requirements with other IFRS 9 requirements around modifications and derecognition, which has been a long-standing debate for years in practice. And second, diversity in the quality and granularity of credit risk disclosures. I think another really interesting area of discussion in the IFRS 9 PIR will be around the application of the effective interest rate method. That isn't really related to impairment and also isn't even really related to the implementation of IFRS 9, as a lot of these issues already existed under the previous financial instrument standards IAS 39. But nonetheless, I think it has become increasingly clear that there are some quite fundamental application questions in this space. And so it seems worth for the board to consider whether standard setting might be warranted in this area. So watch the space. There's certainly some more interesting discussions to come on this, also at the board level.
Then, so that brings us to the end of our podcast. Karsten, thank you as always for the update, and thank you to our listeners. To never miss an episode of IFRS Talks, remember to subscribe wherever you get your podcasts. And until next time, Happy Accounting.
Thank you very much.
This podcast has been brought to you by PricewaterhouseCoopers LLP. This content is for general information purposes and is not a substitution for consultation with professional advisors.